How does probate work if the will has been destroyed? Have you ever wondered what happens when a will is destroyed? This situation can complicate the probate process, but it is still manageable. Probate is the legal procedure that distributes a deceased person's estate according to their will, or, if there is no valid will, according to state intestacy laws. So, what steps do you need to take if the will has been destroyed? First, you will need to file a formal petition with the probate court. This petition must explain the circumstances surrounding the loss or destruction of the will. You should include details about when and how the will was lost or destroyed, along with any evidence that supports its prior existence and contents. Next, you will face a challenge. Courts generally assume that if a will is destroyed by the testator, it was done intentionally to revoke it. To move forward, you must provide evidence that shows the destruction was accidental or that the testator did not intend to revoke the will. Since the original will is not available, you will need to prove its terms. This proof can come from several sources. You can present testimony from at least 2 disinterested witnesses who can confirm the will's contents and validity. Alternatively, if you have a correct and complete copy of the will, this may reduce the number of witnesses needed. Other documentary evidence, such as drafts or notes, can also help establish the will's provisions. Keep in mind that different states have specific laws regarding lost or destroyed wills. Some states requiring a petition to establish and probate the lost or destroyed will. This petition must include statements of facts and the contents of the will. Additionally, the will must have been properly executed, meaning it was signed by the testator and witnessed according to state requirements. Once you have gathered all the necessary evidence, the probate court will review it to determine whether to admit the destroyed will to probate. If the court is satisfied that the will was valid and that its terms can be reliably established, it will admit the will and proceed with the estate administration. From an elder law and estate planning perspective, it is wise to advise clients to keep original wills in safe places. Creating multiple copies or digital backups can also be beneficial. If a will is destroyed, having credible witnesses or copies can significantly ease the probate process. If you cannot prove the will, the estate may be distributed as if there were no will, which could lead to outcomes that do not align with the decedent's wishes. In summary, probate of a destroyed will involves filing a court petition, overcoming the presumption of revocation, and providing clear proof of the will's contents. The court's acceptance of a destroyed will depend on the strength of the evidence and compliance with legal formalities. This process ensures that even if the original document is lost, the testator's intentions can still be honored where possible.